welcome to all our prestigious guests, and I am delighted and honored to leave the floor to the member of the board of the University of Rome Tor Vergata, Professor Riccardo Cardilli, Professor of Law, Riccardo Cardilli.
Thank you very much, Gustavo Piga. I'm very happy to be here today, and I am honored as a member of Board of Governors of our university, University of Rome Tor Vergata, because I think that this conference, this is the third conference on public procurement, is a very trophy conference of our university. I mean that this conference is very important for us, for our internationalization, and for this reason I'm honored also to welcome you in this beautiful Villa Mondragone. This Villa Mondragone is a very important history, and here was signed the new calendar. So in this place, the time was signed for the past, the present, and the future. And I think that this conference of my friend Gustavo Pica has organized on Global Procurement Conference is a conference for the future. It's a conference for the future because the global adjective that he used in the title of the conference is something that for us, from a legal perspective, but also in economics perspective, social perspective, is very important. From a legal point of view, I'm a jurist, I'm a lawyer, I'm professor of Roman law. I think that is very important because the globalization and the anti-globalization debate of today has, from a legal perspective, a lot of problems. First of all, the resistance of national law. So in a global perspective, from a global point of view, we have to understand how can we solve the problem of national law, the resistance of national law. Also, the international law is not the solution. So also the international law is not enough to solve the problems, also in the public-private procurement. So the first step from a legal point of view is the harmonization of law. Harmonization of law that it's very hard to manage. It's hard in Europe, for example. So we have to understand how much is difficult in a global, in a world perspective. How it's possible to find a common rule in a public procurement in international perspective. It's possible to find common legal rules between Europe, Africa, Asia, America, and the legal scholars have a very strong mind on the perspective of national law. So we have to move very fast in another direction. This is why the historical roots of the national law can be useful. That's why also an historical perspective can be useful to solve this problem. And you are inside this movement in the public procurement because, for example, in Europe, we are trying very hard to find common rules in the public procurement. The role of the e-procurement just to make possible to the small and medium enterprise to come inside this big market of the public European procurement? Or maybe the problem of the culture of integrity. How it's possible, for example, to manage the problem of integrity in the relation between Europe, Africa, Asia, and America. So I just would like to assume here in this 2 days conference that a lot of these points are on the floor. I have seen the scholars that are going to speak, very important persons, very important professor or lawyers or economists, of social scholars. And how can these, for example, how can we manage for the future the innovation through a public procurement, new perspective? How it's possible to solve the problem of corruption? How is possible to modernizing the public administration? And so, have you heard a lot of questions, a lot of problems? So I leave you the floor for the debate to tease this kind of problems. And I think that conferences like these are very important for the future of our society. So thank you very much, Gustavo Pica. Thank you to all of you, and I hope that the conference will be for sure successful in the next days. Goodbye.
Thank you so much to my dear friend and colleague, Professor Cardilli, who has already set the stage for the debates to come in this 1 day and a half plus ceremony. Let me say good morning to all of you and welcome. Some thanks are in order, beside obviously the thanks to my president, the rector, and Professor Cardilli, who represent the institutions that have always surrounded our activity on procurement with an environment that has allowed us to be effective and efficient as we always wish to be. Let me also thank the institution with which over these years we have been able to reach what we believe are high standards of training and debating, which is the European Bank for Reconstruction and Development. In particular, I have to acknowledge with great sadness, I must say, but with a smile, the absence of a key pillar of these 6 years, which is the head of procurement at EBRD, Jan Jackold. You can understand that Jack is not here because the weather is wonderful, and so we all know that when Jack arrives, even in the middle of August, storms occur. You will notice the absence of Jack also in other moments of these 2 days, and also the presence of my dear friend Veljko Sikirica, who has always done so much. I don't see him now, but I'm sure he's taking pictures. There you go. I'm not surprised. And where is Guido Paolucci, who thought of launching all this? Thank you, Guido, for being here. Our heart goes to you. Let me also say how proud we are to host here an incredible number of distinguished professionals in the field of public procurement that we have had the honor to interact with during our masters. Obviously, the students of the IMPPM in Rome of this current edition, but I've seen many of the Alumni Association of previous editions. But also let me stress how honored we are to receive a huge delegation here today of the first edition of our joint master with the University of Belgrade. The delegation is obviously headed by my friend and colleague Dobrosav Milovanovic, which I hope I can see somewhere. Hello, Bata, and welcome to all the students of the first edition of the Master in Belgrade, wonderful officials. Let me also say thank you for, on behalf of all of you, to the wonderful team that has made these 2 days possible, in particular the Vice Director of the Master, Annalisa. You've done a fantastic job. As usual, Annalisa, thank you so much. You will see her later on as chair of one of the sessions. And nothing of this, Annalisa and I agree, could have been done without the fantastic help of the staff, Maria Cristina Cerri and Simona Rippo in particular. Thank you for the job that you've done in these endless nights. Greta and Chiara will be helping you for all that is required during these 2 days to accommodate your needs. Let me just remind you also, not forgetting that it's true that EBRD is the great sponsor of this master, but the support that we have had over these past years by African Development Bank is really an important one. So I have just 3 things to say before starting. One is about topics, one is about people, and one is about the format of the conference. Professor Cardilli has already stressed enough, so I don't need to go into further details, why we believe that the word global is so important. Let me talk a little bit about the 6 topics of this year. By the way, they were not quote unquote chosen by us. They were chosen by the participants of the previous edition of last year Global Conference. We thought that we would do a questionnaire, and we are happy and delighted that we will do this obviously also at the end of this year to see what will be the perfect topics for the 4th next year conference. But let me start with a statement that I read on a report that was done in a conference on good governance in international development. It's a Brookings Institution report, Reforming Public Procurement in a Compliance-Oriented World. And he claims, correctly so in a sense, that there is too much of a singular focus on the bidding and award stage of the cycle. And it also criticizes IFI policies for this. And it says this approach only related to that part of the story of procurement is seriously inadequate. So I started looking at the topics of today, and there is no award part. It's fantastic, right? We have responded in the best possible way. We will have one session on processes, e-procurement, one on institutions, very important, one on operations, on PPP, one on capacity building, one on organization with the issue of centralization, one on contract management, which we will start with. So it's not true, or at least the word is moving around, and we all understand that when we talk about public procurement, we have to go well beyond the stage of the awarding process, which doesn't mean that next year maybe we will not cover it, but that we have certainly aware of the largeness of the issues that our profession is involved with. The second issue is about people. Professor Cardilli has already stressed what is our core principle, so I'm not going to go into that too much. The students know it by heart. We cherish interdisciplinarity. We do believe that without interdisciplinarity, public procurement is nothing. And so you will see it by the amount of people that come from different disciplines. You have here the bios, and I will not read from them, of all our fantastically prestigious guests. They come and they have histories and experiences that touch upon the various fields of that procurement is composed of. What I really wanted to say is another feature that we really cherish with Annalisa about this conference, is that we want to mix academics and people from institutions. So I just went down the line, and basically we are 6 to 6. So in terms of shootouts, which is a popular thing recently, we are really tied. There is 6 academicians, or 6 people who like to call themselves academicians, and 6 people who like to call themselves representatives of institutions. But this is not a shootout. This is not one against the other. The great success of what Tor Vergata has done over the years, but also other colleagues in other universities have done, is always to try to cherish, and this is a wonderful thing about the topic that we work on, public procurement. We've always wanted to mix the practical and the theory, the practical and the theoretical approach, so that to get the best of the 2 worlds in finding solutions. One last thing is about the format that we've always loved. It's worked very nicely. I say hello to Paolo, with whom we have organized a fantastic 2nd procurement conference last year. Thank you, Paolo. We have a format that is pretty standard and that we like a lot. We give a lot of time. We take a lot of time. We like the idea of time. We don't want to rush. So we give basically 30 minutes to our speakers. They can take all the time they want, 30 minutes, then they'll start seeing me doing signals, strange signals, but 30 minutes is a wonderful thing. Then the other speaker will speak for 30 minutes. And then there is something that has always been, over the past years, very successful and important, a long time, 30 minutes for debate. So I don't have to stress how much our IM PPM, whether in Belgrade or Rome, students always raise their hands. And they are very, very welcome to do it even before the other people in this session. We want to hear your questions and the answers for the people. Please don't do long questions, do brief questions so that we have a lot of potential for debate. And then, so the format is 1.5 hours for each session, and then a break. So having said this, and thanking again my dear friend Riccardo and all the things that we will do in the future together, and I thank him for being here, also on behalf of the president, I think we can start. And so apparently it's my role to be the chairman. And actually, this is the other thing I should thank, not myself, but the other 5 wonderful friends and colleagues who have agreed to, coming from all over the world, agreed to be chairmen of the several sessions, and their role is obviously very, very important in many ways. So I will stay on this table. I don't know, you want to stay on this table? No, you have to go.
Sorry.
I know you wanted to stay. You told me you wanted to stay. But you have very important things also with Brazilian students and whatnot. And so I call for the first session on contract amendment. Ciao, Riccardo. Here on the floor. Grazie di tutto. My friends Francois Lichère, de l'Université de Lyon 3, and Evgeny Smirnov, European Bank for Reconstruction and Development, and successful teacher of IMPPM. Francois, welcome.
Good morning, everyone. I'm very pleased to be here. It's the second time I'm here, so I'm really grateful to Gustavo and Annalisa for inviting me here. We are starting with the topic of contract amendments, which might be surprising at first sight, because usually we deal with the award of public procurement rather than the performance of public procurement. But as Gustavo said, now we cannot separate the performance of contract and the award, and we'll see later on why. I can see at least 3 good reasons to start with contract amendments this session. The first reason is that, at least at European level, contract performance is now regulated by the directives when it is said, as we will see, that there are certain rules of modifications of public procurement. The second reason is that it's becoming a very hot topic, at least for lawyers, contract amendment. Some would say that it's the hot potato that the lawyer would hand over to another lawyer when it comes to contract amendment or contract modification. The third reason is that by starting with contract amendment, I will get back home early, and therefore I won't have to neither amend or terminate my marriage contract. So thank you very much for allowing me to start with this topic. So the question here, maybe I can start with one theoretical in economy that might explain the need for amendment of contract, is the well-known theory of incomplete contracts, which is not made, as you may know, for the public procurement side. It's a general theory for contracts in general. And so, as you may know, an incomplete contract is defined by Hart in 1995 as a contract which has gaps, missing provisions, and ambiguities, and has to be completed by renegotiation or by the courts. And maybe it's something similar to what in Roman law, and as we heard a Roman professor previously, used to distinguish between stricti juris contract and bona fides contract. I'm not sure if it's exactly the same distinction, but it raised some similarities. And therefore, incomplete contract in real life in public procurement is quite often the case. We are facing incomplete contract. Economists would say it is so because of transaction costs. That is to say, it's too costly to try to set in advance everything that would happen in the future. And which for economists raise some concerns, which are, by the way, called the hold-up problem, which I won't go too much into details, especially because I'm not a specialist, but basically, in this theory, that means that incomplete contracts raise some concerns about inefficiency and bad investments. So the question we are facing here is basically the fact that we have rules, at least at EU level, and we can discuss this later with a more global approach, the fact that we have strict rules of modification of contract, does it affect this legal theory, this economic theory of incomplete contract? That is something that we can discuss later. What are the main reasons for amendment of contract in practice, and from what I see in the practice, being both an academic and also working with law firm? The main reason of amendment in practice, some are not specific to public procurement, some are not specific to public procurement. I can see that it's usually the case because it's difficult to fully identify scope and any requirements in advance, especially with complex contracts. And by the way, a lot of public procurement contracts are quite complex contracts. The second reason can be the lack of anticipation from both parties. Maybe it's because of laziness, maybe it's because of any other reasons. The third reason, it's the idea that at a later stage, there might be opportunities to hand over the contract to third parties as a business opportunity. Some specific reasons to public procurement. One reason, which is sometimes, I think, undermined, is the general interest for public authorities in the sense that they might want to change the public policy. And there might be a general interest in changing the public policy and therefore changing the contract. The second reason is to the question of technical competence. When I'm saying that, I'm referring, and I know there's a section on the professional skills of a procurer, public procurement agent. We know that in some of public authorities, there's no the real competence, technical competence to negotiate a contract. And finally, maybe the most important that I can see in practice is the willingness of blurred contract, or at least blurred clause. For both parties, by the way. These blurred clause may come from the public authorities. And I'm currently in an important case which is at stake, in the sense that not to give enough precision in the contract allows the contracting authority more flexibility. And at a later stage, they would add some precisions on, for example, how to handle public work. And that's very efficient for the public authority. On the other side, we can see that sometimes the private contractor, especially the firms, may wish to have blurred contract so that they can claim at a later stage damages by saying, we haven't planned this in advance. It was not implicit in the contract. And therefore, we need to amend the contract to have more precisions. And that is a current trend as well in practice, at least from what I can see. So what are the issues of amendment of public procurement contract, the legal issue? We're facing conflict between freedom of contract and free access to public procurement. Freedom of contract should allow the parties to amend the contract as they wish, with no restriction at all. On the contrary, what I call free access to public procurement, which is something which is not said as such at EU level, but which is, by the way, a French constitutional principle, but it's underlined at EU level. Free access to public procurement is the idea that any economic operator should have free access to public procurement. Therefore, if there is an amendment to a public contract, if the amendment is important, is what you can see, it should be considered as a new contract and as such subject to a duty to retender as opposed to freedom of contract where we could amend the contract at will. And so what is the current state of law? I'm referring to EU law to this regard, but of course as a basement for discussion later on at more global impact. So it's regulated, it was regulated by the famous case Prestex 2008, which gave examples of what is a material amendment. I'll get back to this later. And one aspect is important is the fact that there's no impact since then of the intention. That is to say, the court won't look at whether the parties had a real intention to amend the contract so as to avoid competitors. No matter what is the intention, whether it was an objective intention to amend because there was a real need, or whether it was to favor someone, it doesn't matter anymore. So this Prestex case was explicit by the new directives, but the new directives went further by allowing some important amendments. So the question now we're facing, at least in the legal point of view, is have we reached the right balance between the contradictory principles, freedom of contract on one side, and free access to public procurement on the other? So I'll just making a distinction between what I call material amendment, that is amendment of the content of the contract, and also amendment to parties of the contract, that is to say, the transfer of contract between economic operators. And to this regard, we can say that there are some flexibilities regarding, to my view, material amendment, but less so regarding the transfer of contracts. So let's start with the relative flexible approach regarding material amendments. So here, it's Article 72 of Directive 2014-24, which allows for 3 possibilities of amendments. And I said in the wrong order, because I'm going to focus in the wrong order, which I view it as the good order, which was, by the way, drafted as the good order, at the end came up in the wrong order. So first, there's no limitation at all if the amendment is not substantial. So what is not substantial is not clearly defined to my view. I'll get back to this later. Best defined only through examples. I'll get back to this later on. Second, there's the de minimis approach. If there an increase with the amendment of 10% or 15% for public work contracts, therefore, and on the condition that the thresholds are respected, therefore the amendment is legal. It was proposed of 5% by the directive, it's now 10%. There's a distinction with public work contracts, but it's the only distinction between public work contracts and other contracts, which raise some concerns, because to my view, there should be more specific exception to public work contracts. Anyway, these conditions are somehow misleading in the directive, because the directive says when there's an increase of 10 to 15% for public work contracts, nobody has to check whether other conditions has to be met. It's a bit misleading since actually there can be examples where there's no increase, and we'll see that in a case later. There's no increase, and nonetheless, it could be illegal because it doesn't meet other conditions. Let's get back to the third amendments, what I call substantial amendments, which are allowed. Substantial amendments which are allowed. There are 3 of them. If clear, precise, and unequivocal review clause are present. That is to say, it was set in advance that we could amend the contract. The main problem here is that we don't know for sure what is a precise clause, and the recital of directive gives some examples, but some kind of obvious examples, like price indexations, but in practice, in real life, it's more complicated. The second one is for unforeseeable circumstances for the contracting authority. Here again, I could give some example later on if you have questions. The recital gives some examples, but still we're facing some concerns. I'm just presenting the exception and then I will comment on these exceptions. Third, for additional work, services, or supplies. But this is subject to condition. You could add additional work, services, or supplies to a contract without retendering, only where a change of contractor, it is said, cannot be made for economic or technical reasons, and then goes some examples, plus, second condition, would cause significant inconvenience or substantial duplication of costs for the contracting authority. 2 conditions which are to be met. The first one, there was this exception existed in the prior directive. The first one had been added the fact that a change of contractor cannot be made for economic reasons. I'm still struggling why an economic reason would explain why we can't change. It's not for technical reason, it's alternative, it could be alternative economic or technical reasons. Finally, there's limitation to those amendments. The contract cannot change the overall nature of the contract, the amendment, and there's usually a 15% maximum increase of price for the last 2 exceptions, not regarding contracting entity, but that's another story. So, just to give some overall assessments, basically, the directive allows for important changes in value. It could be 10%, 15% when it goes to public work. In some situation, it could be 50% of increase of the contract, and there's no limit if the amendment is not substantial or if a clause is present. What are the issues at stake? Basically, and I'm commenting now the case. First question, is general interest protected? Is what I raised in the introduction. It is said, unforeseeable event for contracting authority. But what if it's just a change in public policy? Recently, the city of Paris decided not to amend, but to terminate the contract regarding electric car in Paris. But what if they had decided to amend it so as to replace cars by bicycle, for example, for policy reasons, right? I'm not sure it would be considered as unforeseeable event for public authority. Another question, this exception is only based on unforeseeable event for the public contracting authority, not for the contractor. What if the unforeseeable event is for the contractor? Nothing is said in the directive, and in France we have a theory called imprévision, which is really in favor of contractor. I'm not sure it would fit in this exception. And by the way, it gives damages. The public contracting authority would give damages in case of unforeseeable event for the contractor. So we're facing quite issues on this topic. What is a clear clause? I already stressed that later on. I gave the example. I will finish on this point regarding the interpretation of what is a substantial amendment. And is it consistent with economic considerations? Just to quote the directive, a substantial amendment, says the directive, is where the amendment renders the contract materially different in character from the one initially concluded. What is materially different in character? The directive gives some example. First of all, the modification introduces conditions which, had they been part of the initial procurement procedure, would have allowed for the admission of other candidates. Fine. Second example, the modification changed the economic balance of the contract. So to change the economic balance of the contract could mean that you just increase business opportunities, or does it mean that you increase the profit? I'm more in favor of this second approach, and in a recent case I'm going to talk about the Conseil d'État rule on this point by saying that it would be an increase of profits. And third, the modification extends the scope of the contract considerably. You see how subjective are these examples. So let's take the example, two examples from the case law on this topic, very briefly. The Fin Frog case, 2016, and a case from the Conseil d'État Ville-d'Aix-en-Provence. Fin Frog case, it was actually a case which is pretty rare of diminishing the scope and the importance of the contract. The diminution of the contract by amendment was from a contract from 40 million euros to 12 million euros. And it was considered as a substantial modification. Here, I think we're missing the economist to this regard, because the court ruled, although it was a preliminary ruling, ruled that by principle, it's a substantial modification because there could be smaller firm which has not submit an offer for the first contract, which would be interested for a 10 million euros contract. My point is that I say, why not? But it's not supported by any economic analysis of the relevant market. And I think that the economists could be important to this regard. But I think it's the role of the lawyers to get economists into those kind of cases. And just to compare, a case of the Conseil d'État, Ville-d'Aix-en-Provence, which dealt with concession contract, not public procurement, but it doesn't really matter. The Conseil d'État ruled the same for reduction of contract. What was interesting here is that the city had decided to split the contract in two. It was the operating of car parks, and there was part of the contract, it was underground car parks, and the other was not underground car parks. And they split, and they decided to sell the underground car parks to the company and to leave as the contract for the company the rest. So it was a reduction of the contract by selling part of the contract to the company which was already operating. And the Conseil d'État ruled out. And again, economist analysis could be interested to see whether it's a different relevant market, the fact to operate underground or not underground contract. And here we're missing those analyses. Very briefly, because I'm running out of time, the second question is dealing with the transfer of public contract. That is to say, when one wants to hand over the contract to a third party. By principle, now a transfer of public procurement contract is deemed as a new contract and should therefore be retendered. It's a kind of reverse principle compared to some member states' law which only demanded prior authorization by public authorities. And that's brand new in most of EU member states, is the fact that prior to this price tax case, there was a first competition, a first tender. Once it has been done, every firm had a chance. Once it has been done, then you could decide to hand over the contract to anybody. The competition was made, no issue again. In France, the Conseil d'État decided that there was no duty to retender in case of transfer of contract. It's now the opposite. It's now the opposite, and it's based, I said, it's in line with the suspicion of directives towards contracting authorities and in favor of a free access to public procurement contract for undertakings. EU public procurement is based on protection of the offer rather than of the demand, contrary to traditional member state law. This is something which is not very well known by students, but basically the rules on public procurement was based on suspicion towards undertakings. Now it's quite the opposite. And therefore, this rationale explains the new rule. That is to say, well, if somebody wants to hand over with the prior authorization of the public authority, it has to be retendered. There's no freedom of contract to this regard. Anyway, so just very briefly, Article 72 allows only transfer in 3 restrictive situations. We still find the precise clause. Universal and partial succession, and the third one is very specific to some national member state. So there are still some issues to this regard. Remaining questions, what about the bankrupt company? Now the directive says in case of insolvency, it's an exception where we don't have to retender, but it's not clear whether it is what is at stake is just the fact that it is the trustee of the insolvent company which can be freely chosen, or what if the trustee decide to hand over the contract to a third party? That is not clear. There are also some concern about the change in the consortium. There was a case in ECJ regarding the question of, here it is, the question of consortium, the Oshgard case, but this case was about the award. During the award phase, one member of the consortium dropped out, and the ECJ decided that if the other member can still handle the contract, then we go along. And we are not yet sure about this case being applicable to not only the award phase, but to the performance phase. Just a brief conclusion. Tirole and Saussure, Tirole being a former Nobel Prize of Economy that you may know, proposed in 2015 that we should set a new remedy regarding contract amendments, a specific remedy for state representatives, any third parties, including competitors, which could challenge contract amendments. That's quite interesting. It's not set as such at EU level. I think it's not necessary since there's already some kind of remedy which could be extended to contract amendments. The simple fact that you could challenge the award of a contract, you could use the same remedy to challenge the amendment of the contract. The question here is, how do we know about the amendments? In the directive, it's only in 2 cases that there's a duty to publish an information. Therefore, what we could envisage is just to extend the number of cases where the information should be given. If maybe for any amendment, there should be a contract notice, and therefore the firm could challenge. And finally, if the case law will take into consideration particularities of contracting authorities, I'm not sure, since we tend to focus more on the firms than on contracting authorities, but I leave that for the debate. Thank you very much.
Thank you so much. Thank you so much, Francois, for this precise analysis of the changes introduced by the directive, and also for, as an economist, thank you for putting us at the center stage also on these topics, and for reminding us that within this new EU directive, there is parts of much greater flexibility, and some parts where flexibility indeed has been reduced. Evgeny, your turn. Evgeny Smirnov, European Bank for Reconstruction and Development. 30 minutes also for you, Evgeny.
Sorry. Can we switch? Sorry about it. It's okay. Right, thank you. Good morning, everyone. If you see my voice cracking a bit, you could understand that yesterday Russia unexpectedly won over Spain, and I think that Croatian guys as well as French will be very pleased to probably support their competitors in future, so I'm very sorry for that. Those of you who attended our famous course in Tor Vergata definitely will be aware of this famous triangle of the quality, time, and cost, and this eternal pursuit for the elusive utopia of finding the Pareto optimal combination of those. So essentially, when talking of contract variations, I would like to say that almost everything in life is changing. We know this famous Roman saying, tempor mutantur, unet mutamur nihil, which can equally apply to contracts. So that's why, of course, to find the way how to handle contract variations is very important. And there's always a question where the borderline between the contract variations and works, goods, or services which are beyond the contract. And we've been very well informed by Professor Lichère now about the position of EU directives based on the precedents set by Court of Justice in the EU. But I would like to pull you back maybe more than just a case of Prisatext versus Austria in 2008, but I would like to bring you back to 19th century. The first time when the English court distinguished between the works which belong to the contract and not was certainly such famous case in that aspect in legal framework, case of Thorne versus London Corporation. It was done in 1876. Lord Cairns then distinguished between the additional works that were contemplated by the parties and by the contract and works that were not. And he actually, and I would have to read it because my English is not good enough actually to remember all these peculiarities. He said that additional or where it works so peculiar, so unexpected, and so different from what any person reckoned or calculated upon that is not within the contract at all, shall not be considered as variation to the contract. And of course, different legal frameworks take it in different ways. We know that in many countries of our operations, and we'll talk about them a bit later, the legislation, procurement legislation, completely prohibits any contract variations, and it leads to the situation when the contracts are inflated with provisional sums, in certain cases reaching as high as 40–50% of the contract price. New procurement directives in Article 72, as we've been presented, resolved this issue in a much more constructive way and admitted that contracts cannot stand unamended and modifications are possible, needed, and inevitable. And those of you who practice law within the remit of EU directives or a legislative framework which is built upon that also may know there is this clause, Article 72, which actually directives refer to contract modifications, just slightly more than 1 page. But those who practice also know there is a special practical guide, which is more than 32 pages explaining how to explain, and with all the forms and clarifications, it's about 300 pages. It's that easy to handle. Just you learn the 300 pages by heart and you will settle. So I would not be providing you with details how it's done in Europe. I'm not practicing lawyer, and I know that cases actually are quite limited now, and there are a lot of discussion in legal families how the new directives really would be applied, and I think very interesting cases were presented by Professor Lichère, and actually I think it's very limited scope of cases he could present during very limited time we have to touch upon this issue. So I will be talking about what MDBs do, and especially what EBRD does. May I ask you who know what EBRD stands for? Can you please raise your hand? And I will at least check who are not still asleep. So not everyone knows what EBRD stands for. Oh, come on, guys. Okay, then short introduction what we are. So we've been created 27 years ago when the Berlin Wall collapsed and the mankind embraced this camaraderie of Western and Eastern world, no Cold War anymore. Actually, now I feel like a little bit of deja vu. I feel like when a child I was reading in Pravda about nuclear attacks coming from the United States. It's actually a very similar environment now. But in 1991, the atmosphere was completely different. We lived in a peaceful world, which provided a lot of opportunities for globalization. And our bank was created with the initiative of President Mitterrand and first president of the bank, Monsieur Attali, who created a great institution which was intended to help countries on their path from centrally planned economies to the market-based economies and building democratic society. At the time, our paid capital was just 10 billion euro. Now it's 30 billion. We have AAA rating by all agencies, despite the shareholders of our bank. And of those, we have plenty. And soon we expect India to join the chorus. We called European Bank, but as you know, it's a cliche. We work in 3 continents: Asia, Europe, and Africa. We are not owned by Europe. We are not subject to European directives. We are owned, as I said, by 65 countries and 2 international organizations, and countries coming from all continents, except Antarctica, of course. And we originally started our work in socialist or post-socialist camp in Eastern Europe, but now, as I said, we work in much broader geographical area. Here is the countries we are working in. And our bank is actually builds its operation on commercial principles. Therefore, 70% of our operations in private sector and about 30% in public sector. We invested quite well in recent years, and we're very proud to say for every euro we invested, we managed to attract 3 euros from other financiers or clients. And of course, in those operations, which currently raises to about 9 billion a year and about 2 billion or so in the public sector, we need some support, regulatory support. And for that, we use certain policies which recently were amended. Last November, we have some new modification of our policies. We also have some policies for financing private parties to concessions. Policies, like many golden rules in procurement, are resting on the fundamental principle of economy, efficiency, equality, transparency, and so on and so forth. You all know that pretty well. But there are some specifics. Our bank, fundamental consideration is that clients are in charge of procurement. They do projects. And our role is kind of two-handed. On one hand, we're good policemen. We assist and advise and support. On the other hand, we're bad policemen. We monitor how our clients do projects and actually whether they meet our expectations. So this is reflected on this slide. And in brief, if actually would like to take anything from this conference about EBRD procurement, that is a slide for you. We believe that procurement is not a ritual dance. Procurement is a project implementation risk management tool. And therefore, we believe that procurement shall be seen not as a process from identification or invitation for tender and up to contract award, but shall start from conceiving of the project and live with the project until the end of life cycle of it. And of course, like anything in risk management, by minimizing the risks, you get better results. And to help us with minimizing risk, we also believe in fair and balanced risk allocation. For that, we use standard documents, which we quite happily harmonizing with our colleagues in arms, World Bank, African Development Bank, Asian Development Bank, and others. But also we use internationally recognized forms of contract, which provide quite well-tested, balanced risk allocation. When it comes to contract evaluation, we believe that the subjectivity, and I will touch upon that a bit later, is very dangerous in public procurement, and therefore we believe that everything which needs to be expressed shall be expressed in monetary terms. So this famous, or some would say infamous, MIT principle underlying the EU directives, in our interpretation, shall be done through applying life cycle cost calculations using net present value and everything based on monetary calculations. And I think that Gustavo definitely can enlighten you how that can be applied in the best possible way, looking at it from macroeconomic or microeconomic perspective for the contract you take into account. And of course, and actually I always like to refer to the letters to Hebrews written by one of the disciples of Jesus, the disciple Paul, who said, law has never done anything better, and therefore you can provide for best regulation in the world, but if you do not have well-trained people, qualified people applying these regulations, you will never achieve results you plan. Therefore, for many years, with Gustavo's leadership and great help. We're running this course in Tor Vergata. We believe it's our small contribution to make this world better. And as a bank, we provide broad assistance to our client, and of course, we cannot stop short of fighting, or better, preventing corruption. And it comes from the agreement establishing the bank, which said quite clearly what our shareholders, our founders, wanted from us. And since the bank was created using taxpayer money, and though we made huge profit and created a lot of wealth for our kind of operations, our client and ourselves, I mean, as an institution, we still have very solid requirements with regard to fiduciary oversight over our operations, which is reflected later in our procurement policy and rules. I wouldn't be reading you what's on the screen. I'm sure you already finished your reading, and those who are still not asleep. I will tell you why procurement variations shall not be only looked from a legal perspective, and not only from a competition focus, as many of our countries, and even EU directives, as we heard, are doing. They're looking at mainly from a perspective of competition. But if you look where we are operating, you'll see this map. And map is painted red, very, very rich. Not because these countries are ex-communist, but because they have a very high level of corruption in them. And our bank has special policy on prohibited practices, we call it, which provides for quite extensive list of potential breaches of all sorts of norms, and they are listed here on the bullet points. And in this environment, we cannot just focus on whether it was fair or unfair to competitors. We also need to prevent variation of the contracts as a main tool for corruption. Many years ago, I think more than 20 years ago, World Bank did sort of survey, and the result of the survey was quite astonishing. So they came to conclusion that when it comes to corruption, that only 5% of corruption happening during the tendering stage, and 95% when the contracts are signed. I think it's pretty obvious, because when tender is in place, all lights sound the situation. It's like everyone is naked on stage, everyone looks at each other, but as soon as contract is signed, curtains are drawn, no one sees what's happening, and therefore humans' opportunism comes at its best. And as you all know, as sociologists say, 5% of human population are totally honest, 5% are totally dishonest, but 90% of us are opportunists. So when the opportunity arises, we may normally see it. Of course, the level of opportunism of each of us is different, and all procurement regulation historically was an instrument to shift our opportunism towards most saint approach rather than evil approach. So, but still, we didn't succeed. We know that corruption happens, and the recent researches by PricewaterhouseCoopers show that level of corruption within EU in public procurement rises from 3 to 7%, which is actually not far away from our country's operation when from 3 to 50%, actually, in certain cases. So, actually, being an engineer by my first education, I believe everything can be expressed in formal way. So this is one of the attempt to expand a little bit of work done by some Danish academics in that respect, and I just thought that it looks more sophisticated than it really is. But those of you who are attentive enough will see abbreviation of the words at the bottom of the formula. And if you read the left column in vertical way, you will see that if you exercise proper care, procurement would be less open to corruption. But corruption is an interesting phenomenon. And you need, of course, two to tango. You cannot do corruption one-sided. And it's very funny, I always find in the regulatory framework and court cases when almost always, only one party is actually punished. It's very surprisingly. So how corruption may happen if it's only someone? It's almost like love. It's impossible to do alone. You know, you need to have someone next to you, actually, to enjoy it fully. So, and the key factors in corruption, actually, and whether you try to prevent or investigate, there are three critical considerations. It's influence, competence, and ability to pay. But it would be nice if it was that simple. In reality, the world become more and more complex, and it's much more difficult and to trace and find the way how corruption is happening, because the combination of different tools, mechanisms, and transactions involved nowadays makes it really impractical, if not impossible, to trace fully. And that's why we see so little cases on corruption being in public domain. And I'm telling you that as member of anti-corruption network of OECD experts, which I would have to attend tonight even, so would unfortunately miss the great event scheduled for tonight. But I hope maybe next conference I will indulge in it. What are most typical red flags when it comes to contract implementation phase, which of course show us that this is where and how most commonly corruption is happening. If you see that some of the cases which you mentioned by Professor Lichère may also be seen in this slide, though of course the consideration in the European Court of Justice were not about what was underlying situation, but you can see certain red flags even in the cases provided before. And you can see from this list that the most typical red flag, the large number of variations, the high level, change of circumstances, and so on and so forth. But what actually EBRD does about it? In our practice, largely similar to other MDBs, but of course, they have this, every of us have our specifics. We can approach it differently. But let me tell you what actually EBRD position is. The first fundamental point is we believe variations are inevitable. So not in any shape or form, we will disregard the fact that variation is happening. This is real life situation. And life is not black and white. It's not even 50 shades of gray. It's actually much more complex and much more interesting, actually, which gives us a lot of food for thoughts. And actually, we came to the conclusion that it's possible to regulate it to the details. That's why we decided to stop on principle base how we will approach it. But very similar in considerations which were taken by European Court of Justice in few cases are linked to that, and we just trying to see whether it provides, it's reasonable of course, and whether it's consideration of economy, efficiency, and fairness are taken into account, and of course we're verifying if there is no corruption. But how do we do that? One thing is to claim certain things, I think is to put our money where our mouth is, so to speak. And for that, we do a few things. And I think so far we are quite maybe lucky, maybe happy, maybe what we are doing really brings the fruits. And this is, of course, education of the clients. We believe it's critical and a very important cornerstone of any successful contract implementation. Use of well-structured contracts, as I said, internationally recognized forms of contract, and since we finance a lot of works, FIDIC is our one of the main baseline contract conditions we are using. We also believe that the people who are involved in project implementation shall be of high quality and professional integrity, and therefore selection of highly qualified engineers is critical. You know that concept of dispute prevention, dispute resolution, of course, is in 16th century, one of the famous doctors said prevention is better than cure. But actually, the modern concept of adjudication shifts from resolution of conflicts to prevention of conflicts. We use lender monitors because resources of the banks are quite limited, so we need external support. So these lender monitors work for us. They visit sites, they checking what's going on, helping to resolve conflicting situations, and also provide their professional opinion when we need it, when verification of the contract coming to our desks. Of course, you would not be able to prevent anything if you do not monitor project implementation properly. We have some systems in place for this monitoring, which really work reasonably well, but of course has plenty of room for improvements. We undertake site visits. In most critical and conflicting cases, we engage impartial experts and regularly doing performance audit of the contracts and projects when they completed. That's the approach which really helps us to achieve reasonably good results in our consultation in very complex and ever-changing legal and even geopolitical environment. It's not an easy task, but it's important to have a clear understanding of what the project risk and variations represent, so such risks, and have clear principle-based approach and how to handle it and certain mechanism in place. So that's essentially, if you have any further questions, and on this note, I would like to thank you very much. Grazie mille.
Thank you so much. Now we have, with both presentations, as we hoped, the full picture of the various trade-offs that are involved. I will want to go back to the slide of Evgeny, but that's not my role to ask the first question. On the slide of what do we do about it, I would like also to ask you later on, what does the client that receives the money think about that slide? Don't they want to deal with that slide on their own? And how do you deal with the fact that there's two people that want to do something about it? But we have a microphone, I hope. We do? Okay.
We have at least 4 on the table.
Yes, but we want a microphone for the people. Yes. So please, questions from the floor, raise your hand, and please state your name. Remember, this is the good part.
Thank you, Gustavo Pica, and thank you to wonderful presenters. I'm from China, Central University of Finance and Economics, which is based in Beijing. And I got one question regarding the contract amendment, especially in the context of public-private partnerships. You know, the case you mentioned, right? The change the members consortium in the wording, both in the wording phase and in the implementation phase. Another point, sometimes, you know, the consortium members set up a project company to implement a kind of, for example, PPP project. What if, you know, the shareholders, you know, it changes, the shareholder of the company, the special purpose vehicle company changes. What the you know, the economic and legal point of view in the context of EU law and probably French law? Thank you very much.
Thank you. These are very important and good questions. Regarding the change of consortium, the problem is that the case I mentioned is, as you said, is regarding the award phase. And the ECJ ruled that it was legal to, during the award phase, change the consortium if one part of the consortium is avoided, but the other part can handle the contract. And if it doesn't imply an advantage for it. In the case, it said there was no advantage. The problem is that when it comes to the contract performance, I'm not sure the reasoning would be the same. You could consider that it's not a new contractor, because if it's still the same firm that will perform the contract, there's no new contractor. On the other hand, you could consider that since there was a consortium, so let's say 2 firms in the consortium, if one step out, the other would have the market opportunity to handle the other part of the contract. And therefore, as I say, the rationale of EU law is based on free access to public procurement. You could consider that it's not the same contractor. It's not the consortium anymore. And so there should be sort of right for economic competitor to get in the contract. So we don't have the answer right now. My view is that we should give some flexibility to this regard and extend what had been decided at the award stage for the performance stage. But I'm not sure it would be the position of European Court of Justice. As you may guess, I'm quite in favor of a more pro-public authority approach than a firm approach, or at least to find a right balance. So I'm not sure it will be the case. Regarding the second question, so there was the question regarding, the change of shareholders. Usually it's not considered as a new contract. It's not considered as a transfer of contract because it's in the directive at EU level that it's kind of internal restructuring, and therefore it should be legal. However, in practice, what happens sometimes is that you could find in contract that at least in case of change of shareholders, there should be a prior authorization of the public authority, which doesn't mean that it should be a retender. It's just that there's a prior authorization by the public authority in case of change of shareholders. But as such, regarding public procurement law, if there's a change of shareholders, it is still legally the same firm and with the same skills, and it should be considered as legal.
A change of any size or a minimum size of shareholders?
Any size, as long as it's the same firm which will perform the contract. In a sense, it's the same people, the same, it's just a question of shareholders. So for the moment, actually it wasn't really ruled as such. Nothing is said on shareholders, but we can consider that it's one of the exceptions. It's a kind of internal restructuring.
There's a point that, shareholders
Hold on for the mic.
There's a point, the shareholders as a SPV company, actually a consortium member, who win the bid. So if you change, the consortium will evaluate it based on, procurement laws. When you change the members of the consortium, who are now the shareholders of the SPV company, actually you may change, the roles, the competition roles previously based. So there's an argument, based on this. Thank you very much.
It would not be entirely about EU directives and approaches, but since our bank financed a lot of PPPs around our region, so I would tell you our views on that. Once again, we believe that changing the consortium is not something unique. It happens very often. And we believe that if you look, to start with, contract is not the tender. It's also another point which needs to be taken into account. And from our perspective, contract shall be looked on its own merit, and many of the most common contract conditions provide that contractor, in this case might be SPV or the contractor hired by SPV or some whoever is the contractor named in the contract, or his legal successor in title. So it means that changes are possible and envisaged by the contract. Moreover, normal contracts envisage assignment of the contract. Therefore, we can even assign it. And at the end of the day, I think it was very well said by Professor Lichère at the beginning. He said, unfortunate drift of legal interpretation within the EU currently focuses too much on the protection of competition rather than interests of public. And actually, that fundamental principle of procurement, whether it's private to public, is to delivering goods, works, and services to public. And people forget they're throwing the baby with the bathwater. They're focusing too much on rituals and regulations, forgetting the purpose and beneficiary shall be public. And in case of changing of parties to the contract, public does not suffer as soon as the new parties are qualified to perform the contract, capable to perform the contract satisfactorily. Therefore, our position is that changes to the contractor composition are possible. They shall not be free, and of course, employer shall be happy with those changes. Employer shall control it, and therefore, contract provisions say the consortium shall not change its composition without prior written consent of the client, because client may be unhappy with free changes of partners because he wants to be sure that partners are qualified to do the job. Roles within the consortium also can change, as you rightly said. Our main concern, though, with PPP and SPV is not so much whether they reshuffle composition of consortium member, and we are not even touching the shareholding. Can you imagine it's publicly traded company is a contractor. So the owners can change every minute, you know, and magnitude of those also. So we do not touch that even. But what our main concern with SPVs and contractors, when very often they affiliate or partners in different way to the shareholders of SPVs, is rather this arm's length control of the contract, because through kind of cozy arrangements, very often the SPVs sort of channeling money out of public purse through the contractors they hire. They paying double price to the contractor, receiving back through the back door equity, essentially the money they invested as equity, and therefore public is actually robbed. Later, SPV walks away unharmed, and public, and a recent case of Karelion actually in UK, I think, is an excellent example, or rather devastating example of how SPV and PPP arrangement may be detrimental to public interest and how difficult it is. And actually, as you can see, in time of crisis, private companies go to government for support, but in time when they make huge profit, they never come to the government saying, I have surplus profit, let me share with you, dear government or public. You know, they buying helicopters, yachts, houses on Côte d'Azur, but when difficult time comes, they're running to the treasuries and asking for more money. Okay, that's it.
Questions? Yes.
Dobro sam Milovanović, Bergled Law
Please,
School.
Bata, please stand up. We don't see you. Thank you so much.
Thank you. Thank you very much that you raised this issue of public interest. Because in neoliberal economy, very often we are forgetting why we are here. And that is the crucial issue, how to protect public interest. And as you mentioned, not only in the process, what you mentioned, when you are awarding contract, but during the whole period of performance, and it could be for several years. And that is why I am a lawyer, but I will have this economic approach. These formal changes is not so important. Crucial is if there are some changes that could jeopardize fulfilling of the idea of public interest and how much we are delivering the quality that was promised. And I think that this is one of the... I think I was so loud before.
Vicino.
So,
And
okay. And I agree with you that because I was at the stock exchange and the regulator of financial markets, and as you know, changes are in every second. So one thing is who is shareholder. Then another thing is who is managing the company, because sometimes the changes of shareholders could provide changes in the management, and that could maybe even more influence than the changes of stakeholders. So I think that we have to think substantially, as you mentioned, and to take care about those elements. Thank you.
I can provide you with an example of from your city and your country. This famous Ada Bridge, you know, that Poor won it from Strabag many years ago, because at the time Strabag was bought by Deripaska, who is now a sanctioned person by FAC, and actually top management of Strabag moved to Poor at the time. Actually, we gave them a little bit of a cutting edge in this competition, so they built this bridge.
Thank you for the presentation. I'm Joseph from 6th edition of IMPPM in Rome and Ministry of Interior, Slovak Republic. I would like to ask Professor Lichère about his view on amendments that prolongate the contracts, specifically in a situation of a de minimis. And how do you calculate the monetary value of the change, so you know that it is under 10% or 15% for the works? how would you calculate this change? And maybe this is a question also for Professor Smirnov. Thank you.
Yeah, I guess we should be two of us to answer the question. It's not easy. Just on the question of duration, it's a good question because there's nothing in the directives on this specific topic. And especially, by the way, it's also a question regarding insolvent companies, because usually in case of insolvency and bankruptcy, if ever you find somebody else, it's quite likely that there should be a delay in performing the contract, and therefore it should be, and I didn't say that, but in the directive they said when it is allowed to transfer the contract, there's one condition, is that you should not add substantial change in the contract. Never. So it's quite restrictive. In that case, the question is, of course, there should be an extension of the duration of the contract in practice, but when do you think that it's going to be substantial? So let's say it's under the threshold of 10%, then, well, the way you calculate, I think the issue is what do you put in the contract as such, what is the price of the contract? Usually it's quite simple, it's just the price fixed in the contract. Sometimes you add additional potential incomes, like advertising, and then it becomes more complex. I think it's just the question of a fixed price in advance. I don't think that maybe you have some example in mind that it should be that complex to calculate 10%, or do you have something more complex in mind regarding this increase in price? Because in
Okay, thank you. We were dealing with this kind of contract changes for some time, and we have a communication from European Commission in that way that every time you calculate, okay, you can prolong the contract under the de minimis part, but always you have to calculate monetary value of that change. And sometimes for us it's hard. Let's say we have a service contract for 1 year, contract for services, for consultants, let's say. And you need maybe more 2 months to deliver the result. So how are you going to calculate this monetary value?
If you don't mind, I will step in just to complement what was said. Of course, different, as I said at the beginning of my presentation, different legal frameworks approach it differently. We, as a bank, do not set any thresholds because we believe that it's impossible to really regulate the fundamental principle, probably whether the work shall be, contract shall be varied or not, well reflected in this case of Thorne versus London Corporation of 1876. The principle is still there. So to start with, what we adding on shall have relevance to the contract as a fundamental point. Second point with regard to prolongation. Prolongation of the contract, from my perspective, of course, may be inevitable, may be raised by all sorts of things, and you need to distinguish whose fault is that, because many contracts usually include provisions for delay damages by contractor, for example, and if you prolong it, you may be seen as releasing contractor from obligation to pay damages. But very often, the reason for prolongation is beyond contractor's control, and for that, I believe you should use, as a basis, should use critical path method calculation based on Gantt charts, just to demonstrate to any authorities, or even for yourself, for how long contract shall be prolonged. And as I said, in our case, we do not stick with any arbitrarily set thresholds. If there is a good reason, it shall be accepted. And of course, we approach it cautiously, because on one hand, we understand that any contract, when it's prolonged, usually require much more money for all parties. And but there are type of contracts, service contracts, as you mentioned, they can be of different kind. If you have payment on deliverables, probably you're less concerned with the extra cost, may have no extra cost at all. when it's time-based contract, it's a completely different story. And of course, question is if you get any benefits as a representative of public sector from this prolongation. Unfortunately, in majority of cases, we see prolongation being triggered by mishandling, misadministration of contract by public authorities. They do not pay sufficient attention to proper contract administration and management, were often not qualified enough or afraid of taking decisions when they need to be taken. And as we discussed during the lectures, procurement is not science, it's an art underlined by science. So it requires you to approach it with the very holistic view on many things, and probably the direct answer, which I believe EU regulatory framework, very firmly based on Code of Napoleon and a coded approach to regulating many things, is striving to achieve, to provide clear guidance, kind of an algorithm, what do you do in every case. But I think it's like holy grail, it's something, or horizon line. You can always try to reach it, but it always goes further and further. So I think that the practical implication, I've been doing procurement for 25 years, hands-on, practically. I'm just as a practitioner telling you what I believe. You need principle-based approach rather than a detailed regulation, because otherwise you always will be in the catch-22 actually situation.
Okay, maybe just a brief added comment regarding the value, money value. I guess maybe it would be solved through the price indexation clause, and therefore, if you at some point try to amend the contract and then you calculate the price, the 10% increase, you should then calculate not from the fixed price, but from the price as it results from the price indexation clause, which gives a little bit usually flexibility to this regard, and therefore, and then you may avoid the value money problem.
Okay, thank you very much.
Maybe as a golden rule, if you know how you justify your decision, you're probably on the right side, because any authority, if you can really explain the logic, and logic is in favor of protecting public interest, I think in the right side.
Pedro, I see you, but you come next. There's a question here.
Thank you very much. I'm Goran Matesic. I'm coming from Croatia. I would like to pose as a devil's lawyer to presenters with a statement. Actually, this directive and amendment of contract is intervention in member states' legal frame of contract law. And it's very tricky how this directive will implement in different member states, which all of them have different contract laws. In your presentation, Professor Lichère, you said, you mentioned a lot of essential contractual institutes which came from Roman law and are unchangeable so far. So we have pacta sunt servanda, and we have, as you, Professor Smirnov said in a part of your presentation, a huge perception of corruption. And we have then, I'm only naming the problems dealing with contract amendments. And then we have a huge untransparent part of execution of the contracts. So my concerns are mainly, all of you are thinking from, probably Professor Lichère, you are talking about French experience, partly on EU level, tackling Court of Justice case law. But then we have member states level, which is the first level, and it's everyday's practice. And then, due to institutional differences of the appeal system in different countries, That's why I don't have a question for you. I just have a statement. I expect a lot of problems in this area.
The only person who doesn't do any mistake is those who do nothing. If you do anything in your life, you're prone to make some mistake deliberately or inadvertently, and the same with contracts. It's not a perfect system, and I don't think there is any golden solution to that. But I think that EU directives in that respect at least acknowledge importance of existence of modification of contract, while unfortunately if you go further east, you will see legal framework which do not even accept the concept of potential modification. Contract cannot be modified after signing, public contract, and it makes real people of real life on the ground a complete nightmare, because change is happening, it's real life. Everything changes, you know. Spain was winning yesterday, but lost eventually. So.
Don't start Russia and Croatia. Russia and Croatia, no, don't start now, okay? You have 3 days to do that.
Maybe one comment on your point briefly is that what you pointed out, I think, is the lack of, the absence of the principle of good faith when it comes to public contract. That's a very well-known contract principle in general, but it's absent in the directive, and basically we should apply the principle of good faith. Regarding the national interpretation, I do agree that we have different traditions, but when you, as you know, it's the national court which will handle this question, usually with no reference to ECJ, and therefore there could be more flexibility to this regard. There's quite an interesting case regarding the High Court in the UK, where they interpreted the substantial change as very wide, and therefore consider that it was not substantial. It's quite a complicated case, so I can go too much into detail, but it's quite surprising when you read the case that they consider there is no substantial amendment in that case, which means that we still have some rooms at national levels to try to put some flexibilities which are not necessarily present at EU level.
Thank you. Pedro Teles from Swansea University. I was looking at the presentations, and I agree that we should move the focus from not enforcement, but in terms of evaluation or rules from the actual procedure to the contract performance. However, having said that, is that not the question that we're missing the consequences for the causes? When I was a lawyer and I did a lot of public works, as in doing the actual performance of the contracts, most of the changes that were requested by the private party had one motivation only, which was to get more money. And as time went on, I started to understand that that may be because one of the reasons being that public procurement is subject to that economic principle of the winner's curse, that for them to win the contract, that they need to put a value that is so low that is actually unsustainable during the contract performance, and you need to get more money during that performance. And effectively in the UK, for example, we saw that happening quite recently with Carillion, which was one of the biggest public contractors, which had so many contracts that were with a very low profit margin or no profit margin whatsoever, that it eventually went bankrupt.
I think there is a good Hollywood movie about that, and they talk about that greed rules. You know, of course, there is no limitation to people's greed, and the point is, you can never find a sufficient level of profit. And actually, companies very often believe they have minimal profit. And if you talk to contractors, and actually how you calculate profit as well is an interesting question. All of them claim that not enough money in the contract. But if you take a Fortune 500 list of richest people in the world and take top 20 people, none of them owns construction business. So that just to reflect that the greed is always there. And of course they will try to get more money because there's pressure by management, pressure by shareholders. The question is, if public sector is well equipped to withhold this pressure, if they qualified enough, and very often we have situation with when contract essentially is zero-based sum game, and the contractor is very well equipped, can draw on qualified lawyers, qualified engineers, while public servant does not have such support and corrupt very often, unfortunately, in many countries. Maybe not so much in the UK, but in many countries, they just, the people receiving $100 a month are in charge of projects which cost 100 millions. It's very easy to shift the scale of opportunism there. And contractors do that, unfortunately, and we know a sufficient number of precedents, I'll put it that way.
Yeah, thank you, Pedro, for this very interesting question. I think you raised the good point, and I'm always wondering if this peculiar to public procurement. Of course, you can say that, and in practice it doesn't happen every time that the firm would, of course, send a law offer, not really a normal law, but at least very low offer in the perspective of getting more money at a later stage. Is it specific to public procurement? You may find those same side effects in private procurement. Maybe what is specific is that they may count on the weakness of public agent, I'm not mentioning the corrupted agent, just the weakness at a later stage, maybe because the civil servant is fed up with arguing, he say, okay, we'll amend the contract. The politicians that are involved, they know that they have their stadium finished before the political elections, and they won't argue very long on this. So there are, I think, different considerations, which is not necessary to public procurement rules, to my view, which is just linked to public authorities in general. That might be the explanation.
This is interesting also because the private sector uses reputation a lot to avoid this kind of issues, so it would be wonderful to talk about it. I see Abed and I see Velko. Abed. Oh, sorry, I didn't see it. So and Velko and? Yeah, Professor.
Angelo.
Hold on, Angelo, hold on. I'll go.
Good morning. Thank you for your presentation. My name is Abed, Japanese Minister of Finance. I have a short question. If we have a contract which is below the EU threshold, but after the amendment for the contract became above the threshold, what happens in this case and what provisions are being applied? And if these provisions are applied only on the amendment or for the whole contract, and what modifications can be happened?
There's only the answer regarding the 10% increase,
exactly.
Where for this one, you should not be allowed to amend the contract because then you go over a threshold. There's no answer for the other cases where there could be an amendment. So I would say we do have example at the French National Court level because we had already rules before the directive to this regard, and the French court's approach was to say the court would check whether the initial evaluation was objective. The initial evaluation was that I'm talking about the award phase, but it could be extended to contract amendment. And therefore, I think that in that case, the court would look at the same way, whether the price at the beginning was a real price, objective price, and whether, or it was like, for both parties, underestimating the real value of it. So I guess in that case, the amendment could be considered as... Anyway, it's not... The threshold only mentioned for the 10% increase. So if it's another reason why you go over, I think it should be enough to consider that the amendment is legal.
Thank you so much.
My name is Agirim. I'm from Kazakhstan, from sixth generation IMPPM. My question is about the what was said about the corruption, and when the flexibility given for amending the contract brings more corruption because the rules became abused, what Professor Smirnov said. In fact, what I understood is as more trust is between the state and the society, as more flexible are the rules with regards to amendment. Truth? Which means that to gain this trust, there shall be an institutions established within the state. For example, like Ombudsman institution and many others which are in place in UK and probably in Europe, but not very much developed in the CIS countries. And also, which not very developed is that the reputation of a company, what you said before, has a big value by doing business, which also not in place in the CIS countries. And my question is, by the developing of this trust in the procurement sphere, what comes first? First, the regulation shall become less and less flexible, and then we shall observe the results of that. Is it more corruption became because people abuse it more, or is it less because they become more responsible? Or is the society reputational shall become more valuable, and as to say, on the side of society, more development. And only after that, after we're convinced that it's enough fair-minded persons working in the business, only in that case we shall make our rules less rigid. What comes first? Yeah, it's a hard question to answer with one sentence, but if you may.
One sentence, each of us. On corruption, I think we don't reflect enough on the award process. And I'm really sad about the current EU directive, which put emphasis on the need to fight against corruption and to increase integrity. And there's no really, I mean, if you look at the directives, it's very poor. And I've done myself a research on the example of corruption in France with regard to public procurement, just criminal cases in France regarding corruption. Each case of corruption, it was always when someone tried to circumvent the formal rules, tried to negotiate when it was not allowed, or try to avoid a lot of all the rules of competition. And for example, one thing which is very well done in France, and it has changed dramatically the corruption side at local level, is in 1992 we introduced a sort of commission whereby it is the local commission which chose the contractor. And this local commission is elected from the member of the city council, etc. Which means since 1992 that you've got opponents in this local commission from the majority of the city council. And everyone that you know that are in this commission would say it changed dramatically the way it works because there's sort of internal control of how we choose contractors. And this is totally absent of the EU directive, sort of internal way of choosing the contractor. That's just to give you one example on how to handle corruption. It's more on the prevention than on the repression. I mean, both are necessary, but we don't focus enough on preventing corruption, at least at EU level, or even at French level. And just one point on the reputation side, it's not in the EU rules per se, except that you've got one provision which is very important. It is said that in directive that someone could be drop out if it has bad performance, a public contract. Any kind of public contract, not only the public contract of the contracting authority. And that's one part of the directive which can be used to actually delete or avoid bad reputation firms. Even in the French case, the way we implemented it, we said we can terminate a contract if the firm which has the contract is sanctioned for another contract by, let's say, termination or award or damages because they bad before performed another contract. So it's one part of the directive which can be used against bad reputational firms.
Just two words in that respect. Corruption is largely about perception. And even Transparency International called Corruption Perception Index. And indeed, there are a lot of work, and I'm sure Gustavo presented the famous case when there was deep research into Italian procurement, public procurement system, and only 80% of public procurement waste was down to qualification, only 20 corruption, if my recollection of the ratio is correct. And I think it can be seen everywhere. But perception of corruption is a different story. And I think building the trust more important than regulations, because regulations does not happen to stop anything. But trust between state and public, this concept of good faith really would help everyone. But unfortunately, it cannot be done as a revolution, as an evolutionary process. It will take time to achieve, and maybe the answer is not either or, but rather gradual shift from one to the other, working in parallel. And I know in Asia, in former Soviet Union countries, some regulative framework provide for introduction of concept similar to which was described about local procurement arrangements in France, when the legally representative of NGOs, local society are required to be on evaluation committees and verify decisions. I think transparency is largely an answer in building up trust, and I think a lot of work is done now in Europe and further east to provide for e-government and e-procurement and actually disclosing information to people, because very often lack of trust is based on lack of information. And I think it's like trust needs to be gained, and one need to work on it. But it's like with kids, you know, when you trust them, they behave much better. When you try to punish them, you know, I think it's the same. We're all humans, and psychological rules of psychology applies whether it's society or individuals.
Very quickly, two last questions from Belko and Angela.
My name is Veljko Sikirica, photographer, former employee of the Inter-American Development Bank and EBRD, not former from IMPPM yet. And mainly as an engineer, I would like to add a little bit on the triangulation, because I think we had this tango between law and economy so far in the discussion, very much presented. And I would definitely emphasize on basis of my 40 plus years of experience in procurement, to say that as an engineer, good preparation and solid preparation of projects, quality of projects, is one of the cornerstones of our discussion today. If we know what we know, it's easier to make a difference. If we know what the risks are involved in, how much well prepared the projects are, we will know to define whether 10% is too much or too little. Do we move to between 10 and 20 or 15? And that is something which I think engineers overall, like in the cases of, I don't know, big projects, hydro, electric, etc., have been doing all along, and I would suggest it's important also in PPPs, design and build, and all other sorts of projects. You probably remember the building of the pyramids of Giza. 20 years, about 100,000 or more employees paid. And the difference, I think, was after it was finished, it was 0.05%. So I think that's something to think about, or we can compare it with, for example, I think it's TGV in France, and the purchasing of super-duper speed locomotives. And then the end of that story was that about 700 million additional had to be invested to open the stations, which were miscalculated from the onset. So it's not that these facts are not known. I think that we pay less attention, sometimes not attention at all, to the preparation, the quality of preparation of the projects. I would say that in that regard, it's not only on that side, but it is also the quality of people involved in working in that, and the seriousness. If we're taking breaks because we have to run very fast, as Evgeny mentioned, probably the project in Belgrade, the bridge, then these mistakes, and in particular what we're discussing today, I guess, is the uncertainty and difficulty to later on, during the project implementation, to understand, comprehend, and give the order of things regarding the risk as it was calculated or not calculated at all, and then the reference that we have to say, should we go this way and that way? And I believe, from the engineering point of view, just to challenge my friends on the legal side, then the impossibility of how to regulate that, how to frame that, what words to use, what order of regulation, etc. It's a struggle. Trust in the engineers, give them the opportunity, invest on that part, and I believe we will have at least, not less, but at least more organized and structured variations of contracts. Thank you.
Thank you, Marco. Angelo, to close.
Angelo Bianchi. I'm an engineer, and we are discussing about contract management, and we are discussing about how much we can change the contracts. We are in a country, Italy, where we have the head of the anti-corruption agency, who is a lawyer, who is a former prosecutor, and in his opinion, variations are something that you have to avoid in any case, because they are the door to corruption or but of course you have to have a look at the PMI school and for example other school of project management. Variations are not something to avoid. Sometimes you need variations because they are preventive actions or corrective actions, and they are needed in order to achieve the objective of the project. So back to the works contract, and one single suggestion. In my opinion, the FIDIC contract, for example, gives the right to vary to the engineer. But in reality and in real practice, through the particular conditions of contract, is the contracting authority who has the right to vary, because they may put a lot of limitations of this right to vary in the particular conditions. My recommendation is much more attention in the ex-ante control of the international financing institutions to the particular conditions, because that is the door to the corruption. A very late process of evaluation of change control, of request of change. That is the weak point of the contract management, in my opinion.
Yeah, sure.
Short comment on both comments. Taking the example of FIDIC contract, you can see that engineers are part of the game, by the way, because it was made by the engineers. But I think you're right in the sense that preparation is important. But as I said in the introduction, there need to be a willingness of preparation. I can see from the practice side, and I'm working on a case right now, that there's no necessarily a willingness for the public authority to set at least contract quite precisely. And that's the main issue quite often, this has absence of willingness, and therefore it's not necessarily on the private side that comes the devil. Sometimes it's the lack of completeness regarding the public sector. And that's, in theory, in the text, the contract should be precise. In practice, is not necessarily the case, for good reasons. I mean, the reason in the case I'm working on is that they wanted to have more flexibility to say at a later stage, here is how I want you to perform the contract, the public work contract for each stage. Okay, but then the firm made an offer. They didn't know exactly the conditions, and during the contract award phase, they asked 354 questions. That's the exact number. None of the question was answered by the public authority, because they thought by answering they would tie themselves. And they say, let's give us some flexibility. And then the firms made an offer without knowing exactly what they're going to have to do. And therefore, of course, now, at least it gives some room from lawyers, from work from lawyers. So that's a good part of it, but it's not very satisfactory.
As an engineer, I will finish this panel with a joke, actually. I think it once in the court, the judge said the plaintiff side is right, and the other side is right too. Someone from the audience said, no, it's impossible. Someone shot me. He said, you are right as well. So in this particular case, as an engineer judging on legal matters, I think everyone is absolutely right in their suggestions.
So having been a very bad chairman, I want to finish ending up with a very bad reputation. Can I have a yes or no only to this question? You mentioned the paper by Tirole and Saussure, the Nobel Prizes, and they propose for renegotiations of a certain value, higher than a certain amount, mandatory publication of that renegotiation and a standstill period for parties that want to oppose it. So my question to you here is, do you agree or not, yes or no? And to Evgeny, would you recommend it in EBRD, yes or no? No third answer. Yes or no?
No, I think transparency is more important.
So much. I think it was a fantastic session. Thank you to all. We have 30 minutes of break. Enjoy.